The Sixth Amendment's 8 rights, history and application. Imagine being arrested and thrown in jail with no idea what the charges are.
You have no lawyer, and your trial will happen in secret, hundreds of miles from anyone you know. This sounds like a nightmare, but for many people under British rule in the 1700s, it was real. That's exactly why the founders of the United States created the Sixth Amendment. American founders writing the Bill of Rights were responding to centuries of abuse under English law, and courts often used as weapons by the king. People could be locked away for years without a trial. Trials could happen in secret, with defendants often denied basic tools to defend themselves. The Bill of Rights, including the Sixth Amendment, was ratified in 1791 as a powerful response to royal abuse of power. The amendment was designed to make a criminal trial a search for the truth, not just a show before a conviction. The amendment says, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense." First is the right to a speedy trial. In England, the government could crush people by keeping them in jail indefinitely. A person could be arrested and left in a dungeon for years without seeing a courtroom. The founders saw this as tyranny. They knew that justice delayed is justice denied. Speedy trial time limits are set by statute, and if the government does not bring someone to trial within those limits, typically the case is dismissed. The second right is to a public trial. This was a response to infamous English secret court proceedings, like the Star Chamber, where the king's political enemies were tried far from public view. The founders knew that a public trial lets the community keep the judge and prosecutor in check. This right isn't just for the person on trial, it's for all citizens to build trust in the system. The right to a trial by an impartial jury is a foundation of American law. Thomas Jefferson said, "I consider trial by jury as the only anchor ever yet imagined by man, by which government can be held to the principles of its constitution." This has deep roots back to medieval England and the Magna Carta of 1215, which said that no free man shall be seized or imprisoned, except by the lawful judgment of his equals. This principle of being judged by one's peers became a foundation of English common law and the American colonies. Trial by jury is a vital wall between the individual and an overreaching government. A person's fate shouldn't be decided by a government official, but by an impartial jury. The jury can't have biased ideas about the defendant's guilt and must be chosen from the community. For most of American history, this only applied to federal cases. In the 1968 case Duncan v. Louisiana, the Supreme Court decided a jury trial is a fundamental right that states must provide as well. This doesn't typically apply to minor offenses with a punishment of less than 6 months in prison. The right to a jury from one's community is joined by the right to have that trial in one's community. The Sixth Amendment guarantees a trial by an impartial jury of the state and district wherein the crime shall have been committed. This is the venue clause and came from one of the colonists' complaints against the Crown. The British government claimed the power to put a colonist accused of a crime on a ship and transport them to England for trial. This was a major grievance in the Declaration of Independence. A trial thousands of miles away from home, witnesses and family made a fair defense impossible. The venue clause ensures the government can't move a trial to a location for its advantage. The trial stays in the community where the alleged crime actually happened. Imagine being arrested and having no clue why. This English tactic was used to confuse and weaken defendants. The Sixth Amendment's fifth right guarantees that an accused person must be told the specific charges against them. The notice has to be clear and detailed enough for the defendant to understand what the government says they did. This allows the accused and their lawyer to investigate claims, find evidence, and build a defense. Defining the offense also protects against being tried twice for the same crime. The right to confront the witnesses against oneself goes back to English law and was a reaction against trial by affidavit, where accusers could just submit written statements without ever facing the person accused. This made it impossible to challenge what they were saying. The Confrontation Clause gives the defendant the right to be in the courtroom and to cross-examine the people who testify against them. Cross-examination tests if a story is true. It lets a defendant's lawyer poke holes in the prosecution's case and expose biases or shaky testimony. The seventh right guarantees the power of compulsory process to get witnesses on one's side. This is done with a subpoena, which is a legal order from the court. Compulsory process means a defendant can make witnesses show up and testify, even if they'd rather not. In England, defendants were sometimes denied the ability to call witnesses. The Sixth Amendment fixed that imbalance, and in 1967, the Supreme Court extended the right to compulsory process to state criminal trials. The final Sixth Amendment right has perhaps changed the American legal system more than any other: the right to a lawyer. In 18th century England, people accused of serious felonies were denied the right to be represented by a lawyer. The founders knew this was a massive flaw and wrote the right to counsel into the Sixth Amendment. For over 150 years, though, this was seen as the right to hire a lawyer if one had the money. That changed in the 20th century. First, in Powell versus Alabama, 1932, the Supreme Court required a lawyer in death penalty cases. In 1963, a Florida prisoner named Clarence Gideon argued to the Supreme Court that he had been forced to defend himself on a felony charge because he was too poor to hire a lawyer. Without a lawyer, Gideon had been convicted of burglary. In the unanimous decision of Gideon versus Wainwright, the court declared that having a lawyer is fundamental to a fair trial. Justice Hugo Black famously wrote that lawyers in criminal courts are necessities, not luxuries. This ruling established that the government must provide a lawyer for anyone who can't afford one in a felony case. This was later expanded to cover any case with potential jail time of 6 months or greater, leading to modern public defender systems. The right to counsel is so fundamental that it is included in the well-known Miranda warnings, along with the Fifth Amendment right to remain silent. The Sixth Amendment protections, speedy trial, public trial, impartial jury in the proper location, knowing the charges, confronting witnesses, presenting one's own witnesses, and having a lawyer, are a shield designed to protect the individual from massive government power. These rights are safeguards to ensure that Americans accused of a crime don't stand alone, or in darkness but have the Constitution's protections. Continue learning about the heritage of America and the work to balance individual natural rights with the safety and security of society by liking this video and subscribing to Constitutional Soundbites.